Okay, good morning, everyone. I'm Danny Anderson, Executive Director of the Independent Living Resource Center. Thank you for joining us this morning. Just a couple of housekeeping items as we maneuver through this new world of Zoom meetings. This meeting is being closed captioned, and Jacob, our systems change advocate, and myself will be manning the chat box and the Q&A, so please feel free to reach out to us in both of those ways. At this time, I'd like to send it over to Brian to do introductions and start our program. Thank you so much.
Good morning, everybody, and thank you for joining us. So today's webinar is a collaboration between Independent Living Resource Center and CoSART Daily Law here in Santa Barbara. And we're going to talk to you about some of the recent housing protections that have been enacted here in both Santa Barbara County, as well as some protections that have been enacted statewide. Speaking with us today is Elise CoSART Daly. She is a local attorney who practices anti-discrimination, civil rights, and environmental law. She graduated with honors from Loyola Law School and UC Berkeley and has been advocating for social justice for more than 20 years. As principal attorney at CoSART Daily Law, she supports women, people with disabilities, people of color, and members of the LGBTQ community who face discrimination in housing, public spaces, schools, and workplaces. Elise does whatever she can to support those community members as they create a more just, fair, and accessible world. As part of her practice, Elise assists marginalized community members with housing rights issues. I'm Brian Hollander, and I'm also going to speak to you today, and I am the program manager for Independent Living Resource Center, and I have worked in independent living for about 15 years and in social justice work for about, well, most of my about 25-year career. And much of the work that I have done is on discrimination work in various areas, including housing. So I'm going to let Elise start by talking to you about some of the more localized protections that have been enacted in relation to the current COVID-19 pandemic. Elise?
Thanks so much, Brian. I really appreciate the opportunity to speak with you and some of your constituents about these protections. Good morning, everyone. I hope you're doing well today. I want to bring you good news today. So let me give you some good news if you live in Santa Barbara County. There are two things that you should know. First, know that there's currently a pause on any eviction actions in the state of California. That's one very positive thing that we'll chat a little bit about in depth as we talk today. The second thing is, if you live in Santa Barbara County and you currently are struggling financially because of coronavirus or its impacts, there are a number of local ordinances, which is just a fancy word for laws, that protect renters if they need to defer rent, need to wait to pay it, and renters then can wait to pay rent and they can stay in their homes long-term under these ordinances. So I'm going to break that down for you in our conversation today. First, let's talk a little bit about this statewide ban on evictions. And I said ban, but it's really a pause. It's a statewide pause on evictions. What does that mean? It's a statewide pause on evictions. Well, the courts have decided that during the coronavirus crisis and pandemic, people shouldn't be kicked out of their homes, which is the right thing to do. And so what they've said is during the state of emergency or for 90 days after the state of emergency ends, the courts are not going to be processing any eviction actions. And when I say an eviction action, what I mean is when your landlord wants to remove you from your home and goes through a legal process to do that, goes to the court and goes to the sheriff and says, hey, I want to kick this person out. That's what I mean when I'm saying eviction action. So that's great. And that applies to any eviction for any reason. Now, we don't know. We're currently in a state of emergency declared by the governor. And I'm seeing a little note from Danny. Okay, I'll chat a little bit slower. I'm sorry, Captioner, thank you so much for your work. I'll try to chat a little slower for you. Let me just backpedal a second here. So in California, it applies to any eviction for any reason. So you can stay in your home during this time, even if you can't pay rent. If your landlord is trying to get you to move so that they can move into the location, any reason. We currently don't know when the state of emergency will end. But even if it ended, say, today, so today is May 4th, this means that you would be protected from an actual eviction proceeding through August 2nd. So that's a nice buffer of time that you have. There's two exceptions to this rule. One is that if there's an issue of health and safety, so if your staying in your home could hurt someone in your community or your neighbors, if there's some kind of public health issue, if your home has been red tagged or condemned, there's an exception, and this process can be sped up a lot more quickly. And the other thing is that you should know is, so the rulemaking body, the Judicial Council that controls what the courts do, also can decide to rescind the rule. So right now it's 90 days after the state of emergency ends, but there's a possibility that the Judicial Council can say, you know, we've had some additional information and we're going to change that. So it's very important to be reaching out to your legislatures, to the Judicial Council itself, to say, hey, this is really important to protect people. The thing about this rule is it doesn't give you the ability to wait to pay rent if you are financially struggling and stay in your rental long term. The thing about this is it just means that you're not going to get evicted right now, but it will happen down the road. So what should you do if you're in Santa Barbara County and you have been hit hard financially by the coronavirus crisis and you want to stay in your rental long term? Let's say you have a family and you don't want to move out of your neighborhood, or let's say that because of one of your disabilities, it's really difficult to move and you found a place that that's accessible and has had some improvements so that it's better for you and your body. These rules in Santa Barbara County can really help you. So this is the good news in Santa Barbara County. If you are hit hard by the coronavirus crisis, you've lost money, and as a result, you can't pay rent in the month of May, there are rules to protect you. And unfortunately, they vary from place to place in the county of Santa Barbara. So I'm going to try to break it down for you. I'll give you an overview. I'll give you some details about the individual locations. But then I really recommend that you go. I've published a series of articles because unfortunately the local cities haven't given that much information about these protections. You can go to those articles. We'll link to them. That will give you more details, and it'll connect you to other resources that you can reach out to for more detail and information. You can, of course, ask me as well, but I'm going to give more of an overview with some details as we chat today. So the rules are in effect in, let's go from north to south, Guadalupe, Santa Maria, Solvang, Buellton, Goleta, and Santa Barbara, and in unincorporated Santa Barbara County. And what that means is if you live outside of city limits. So Montecito is unincorporated, San Ynez is unincorporated, Gaviota is unincorporated, New Cuyama is unincorporated. The only two places where there are not these protections, unfortunately, are in Lompoc and in Carpinteria. CARP passed a law for commercial tenants that protects them, but they don't have one that protects residential tenants. So if you live in those locations, you're still protected by the statewide pause on evictions, but I really encourage you to reach out to your city council members and to chat with them, to let them know that these sorts of protections are really important and you need them in your city. So I'm going to talk about basically anywhere in Santa Barbara County except for Lompoc and Carp. So in most places, you can defer rent payments in May if you qualify. In some, you can defer in June, and in some, it just lasts until the city council rescinds those. The details are going to vary here. So who can put off paying rent? In most places, except for the city of Santa Barbara, you can defer rent payments for the month of May specifically, and some others. If you have lost money because of coronavirus, the impacts of coronavirus, or the government closures related to coronavirus. And generally it's just, you know, if coronavirus has made you lose a large amount of money and you're struggling to pay rent, you're covered. In Santa Barbara, the ordinance lists some very specific categories, but in effect, it ends up protecting pretty much everyone who's hit hard by coronavirus. But let me just break down those categories for you, and pardon me as I check my notes because they get a little bit detailed. So if you have coronavirus, if you are caring for someone with coronavirus, if you're taking care of kids who have missed school, the school that's been closed because of coronavirus, if you have large medical bills that are not covered by insurance and you've had to pay for coronavirus, excuse me, if you've been laid off, you've lost work hours, or you've lost money because a business or workplace has been closed due to coronavirus, or if you've stayed home because of the stay-at-home order or to try to prevent the spread of coronavirus. Those, and as a result you've lost money, those are all reasons that you can qualify to defer your rent payments. And that's something that's really important to take note of. So it provides this opportunity if you have voluntarily decided to stay home. So let's say you're in a population or you have a health condition that puts you at a higher risk because of coronavirus, and as a result you decide, you know what, I don't feel safe or comfortable going to work. Then, and you lose some money because of that, that qualifies under the Santa Barbara ordinance, and it would qualify under any of the other ordinances as well. So that I just wanted to highlight that. Now, if you qualify, how do you make sure that you stay safe? Because you actually have to take a couple of steps in between to make sure that you can safely wait to pay rent. So you need to tell your landlord. You need to do it in writing. You need to do it within a specific time period from the day that rent is due. And you need to say a couple of specific things. So what do you need to say? Specifically, it's pretty intuitive. You say, hey, I've been impacted by coronavirus. I've lost a lot of money as a result. And because of that, I can't pay rent. And you also need to tell them, in addition, you know, if you can pay some amount of rent, let's say you could even pay like $10 a month. You can say, I can pay you $10 for the month of May, but I need to defer the rest of my rent payments. You need to also provide proof when you do that. So whether it's a layoff letter, whether it's a note from your child's school that says that they can't go to school, whether it's a email message you sent to your employer saying, hey, it's not safe for me to come in, and then a copy of your pay stub showing that you haven't made very much money this month. Those could all qualify as proof. Of course, none of the ordinances tell you what exactly is good proof, but those are some examples. And if you have additional questions, you can always reach out to your resources, to the ILRC. They can chat with you about it. You can reach out to me as well, and we can talk about it to figure out what would be good proof or evidence that you're not able to pay rent because of coronavirus. Now, this proof needs to be sent in when you notify the landlord, except for in Goleta. In Goleta, you don't have to send it in until the rent is due, which is in 12 months. So you don't have to send any kind of evidence or documentation until a year from now. Now you have to do this in writing. And it's a little bit funky because each ordinance tells you different ways that you need to, that different things that constitute writing. In Santa Maria, Buellton, and Goleta, you can text or email your landlord and this qualifies. In other places like Santa Barbara and Solvang, it only mentions email or a hard copy. In unincorporated Santa Barbara County and Guadalupe, it's not clear. So I can't give you legal advice because I'm not your lawyer, but if I were in your position, if I were concerned about deferring rent, what I would probably do if it's accessible to you is I would do a hard copy letter. I'd write a letter to your landlord, I'd date it, I'd take a photo of the letter, I'd take a photo of you or a caregiver or someone on your behalf putting the letter in the mail. And then I would also text or email or call my landlord to let them know that you are not going to be able to pay rent in that month. And that's a good kind of CYA just to make sure you're covered. Now, if sending in a hard copy letter is going to be problematic or difficult for you, double check those articles, reach out to a resource, and they may be able to tell you specifically, oh, you know, hey, in Santa Barbara, you can actually send an email and that'll qualify. And, you know, when you send this information in, there's a timing requirement. In Goleta, you have to tell your landlord by 7 days after the date that rent is due. In Solvang and Santa Barbara, you need to tell your landlord within 20 days after the date that rent is due. In Santa Maria, I'm double checking my notes, Guadalupe and Buellton, it's 30 days after the date that rent is due. And in unincorporated Santa Barbara County, like I see Carrie pointed out, like Summerland, it's unclear. So for example, we're in May, it's May 4th. If you're in Goleta and you are struggling to pay rent, you qualify, you should notify your landlord by May 7th. Now, a best practice is to tell your landlord as soon as possible, because what these protections do is they mean the landlord can't do anything to try to get you out of your home, can't harass you, can't send you any kind of 3-day notice to pay rent or quit. And that's very stressful. If you send a letter now, you're effectively telling your landlord, hey, I qualify for this protection. I'm not going to be able to pay rent, and it's going to circumvent them. It's going to stop them from bothering you about rent because they'll already know. One thing I would also do, it's not required by any of the ordinances, but when you notify your landlord, it would be very helpful to either attach a copy of the ordinance or send a link to the ordinance, send a link to one of the articles that I've put together, just to say, hey, I'm, in legal terms, I'm invoking this protection to be able to defer rent payment. And here's the information for you so that you know that I'm not just making this up. This is based on this specific law. So I would recommend doing that as well. Landlords have to keep any information that you share private. There's a confidentiality clause in almost every single one of the ordinances. So rest assured that your information is required to be kept confidential. Okay, so if you do all this, what does that mean? What actually happens for you? So which rent payments can you defer? As I mentioned before, in every location you can defer May rent. So if you are still hustling to try to get May rent together, you can defer that. In Goleta, it's any rent that's due through May 16th. But the Goleta City Council is going to be thinking about extending the ordinance. It's through they're thinking about extending this ordinance. So I would check in with the city of Goleta around that time to see if they extend it for more time. In Santa Barbara, Buellton, and Solvang, you can wait to pay rent due through May 31st. But that again might be extended by the city council, and this is proving to be more of a crisis than I think we all collectively anticipated, or many of us. And so I imagine they will be considering moving that out further. This is again a good time to reach out to your representatives and say, it's very important that we have this protection. Please extend the ordinance. So keep an eye out for that. In unincorporated Santa Barbara County, so for example, Summerland, Gaviota, San Ynez, Montecito, it's through May 31st or when the local emergency ends, whichever is earlier. I don't think they're going to end the local emergency before May 31st. So it probably will extend through the 31st, but you know, weird things have happened. And then in Santa Maria, the ordinance extends as long as the city council doesn't rescind it. So it's in effect until further notice. So you should be covered in June as well, but keep checking in with the city. Give them a call or give a call to your resources like CAUSE or the ILRC. Guadalupe, you can wait until June 30th, but they again may extend that as well. All right, so then when do you need to pay this rent back? Because it doesn't allow you to skip rent, unfortunately. You still have to pay the rent back. It's basically a loan from your landlord. In Santa Barbara or unincorporated Santa Barbara County, it's not quite clear. The city of Santa Barbara is going to meet on the 12th and talk about that, but they're not certain at this time. In Goleta, you have the longest amount of time. You have 12 months from the end of the local emergency. And the local emergency in Goleta is currently scheduled to end on May 16th. I imagine they will extend that local emergency. So you'll have a significant amount of time to pay that back. So currently the due date for any unpaid rent is May 16th, 2021. In Buellton, Santa Maria, and Guadalupe, you have 6 months from the date those cities lift their state of local emergency. So they're all under a state of local emergency. You have 6 months from the time that they lift that kind of local emergency proclamation. Right now, it's late November, early December. But that can change. That could be extended out. In Solvang, you have 6 months from when the ordinance ends. And so the ordinance is currently slated to end at the end of this month. That should be the end of November. If you utilize these protections, if you wait to pay rent, as I mentioned before, your landlord can't do anything to try to evict you. They can't serve you any kind of eviction notice. They can't harass you. They can't try to intimidate you out. They can't turn off essential services like water or power. They can't refuse to make repairs in your home. They have to treat you, give you a habitable and safe place to live. It's very, very important that they do so, and they can't do anything to try to force you out. They also can't charge you any kind of late fees. They can't penalize you for any of this missed rent. Now, if they do break the ordinance and file an eviction lawsuit against you, if you're in court, it's a defense to that eviction lawsuit. So you can say, hey, I'm bringing my proof of the notification that I sent. It's under this ordinance, and they can't actually evict me. So if it gets that far, it's a defense to eviction. In Guadalupe, Santa Barbara County, Goleta, and Santa Barbara, there are fines and penalties that can be assessed against a landlord that violates the ordinance. They range from $500 to $10,000 in Goleta. And I don't see the cities doing this, but let's say there's a really egregious offender, you can get up to 6 months in jail if you are a landlord and you don't comply with these ordinances. In Buellton, also, you can sue the landlord affirmatively to say, hey, you didn't comply with this ordinance. And you, if you win in court, you can get up to 3 times the actual money that you've lost because they've done something in violation of the ordinance. So that creates a lot of protection for you in terms of trying to enforce. Unfortunately, in some jurisdictions, like Solvang, for example, it doesn't have the same teeth. So there aren't penalties or fines that are assessed against landlords. If you run into issues in solving, reach out to your resources, have someone help advocate for you, because landlords do need to comply with these requirements. There are a couple of additional protections under these ordinances and specific, I'm trying very hard not to say jurisdictions, but specific locations. In Santa Barbara and Solvang, renters can extend their leases through May 31st. So let's say your lease ends sometimes this month and you're concerned about moving during this wild time. You can request in writing, you can send your landlord a letter saying, hey, I'd like to extend my lease, and they have to do it. They have to extend it through the 31st. And in Santa Barbara, if you ask for up to a year extension, they have to give you a year extension. So just something to keep in mind. Now, for Lompoc and Carp residents who are unfortunately left out of these local schemes, there's no ability to defer or wait to pay rent and avoid eviction altogether. You do have that eviction moratorium or the pause on evictions, but there aren't any ways to under the law specifically, wait to pay your rent. Now, what I will say is you can chat with your landlord. Talk to your landlord, send them a message, say, hey, I can pay X amount of rent. You know, can that work for you? I know a couple of tenants, one in Goleta and one in Carpinteria, who actually didn't go through the ordinances, but they talked with their landlords, and I think they're paying something like, one is paying 1/3 of their rent and one is paying half of their rent. They're not going to have to pay it back. It's just an agreement with the landlords, because I think landlords are a little bit concerned as well, because they're getting less money coming in, and so they'd rather have you pay some amount. So that's an option in Lompoc and Carpinteria. And the other thing is advocate, advocate, advocate. Go to your city council, tell them your stories, tell them why it's important for you to have these sorts of protections. There are a number of additional resources that you can reach out to that I've mentioned throughout. I know Brian's going to talk about this a little bit later on, but Legal Aid Foundation of Santa Barbara County is fantastic if you income qualify. They also have some resources for people who are homeowners who income qualify. My lovely colleague, Kate Lee, is just a wonderful person, wonderful attorney, and she can help homeowners. There's California Rural Legal Assistance, CAUSE, the ILRC. You can reach out to me, and you can also call the lawyer referral service. Santa Barbara County has a lawyer referral service, and they can pair you with someone that specializes in this particular area of law. I'm going to add some links. Brian, do you want me to wait until the end to put up the links for some of the articles that connect to the ordinances? How do you want to work that? I think you're on mute.
I apologize. Yeah, you can wait until the end. That way we can provide those links. But also I want to let people know that I'm going to put Jacob's email into our chat box, because if you need some help connecting with some of these resources or with advocacy with a landlord or on any of these issues, or you want to get involved in some advocacy with policymakers, you know, your representatives, we can provide some assistance with that as well.
Great. Yeah, so I'll hold off until the end, but I can provide some of those links later.
Okay. So thank you, Elise, and I wanted to make sure that you've had a chance to convey everything that you wanted to convey. Are we doing, Jacob, are we doing questions and answers after both of us speak? Yes, okay. So hi. So in addition to some of the current protections that are in place as a result of the COVID-19 pandemic, There are some recent additional protections for renters in the state of California. Some of them are around getting an apartment, and then some of them are around keeping an apartment once you receive one. What I want to address first is some protections that have been enacted here in the state of California. And these are statewide protections. So where Elise was talking about some of the current protections that are a result of the current states of emergency in different cities and towns throughout Santa Barbara County, these protections are statewide. And some of these are protections that we worked on in the ILRC, and some of you probably did some advocacy on some of this. And the main area that I wanted to discuss is protections around what's called source of income. I'm going to share my screen in just a moment, just to give you a look at some slides that I'm going to use as a little bit of a cheat sheet to talk about this. But essentially, California has statewide protections based on certain characteristics, and what they do is prevent discrimination and harassment on the basis of certain characteristics, which are known as protected characteristics. In the last legislative year, and going into effect on January 1st of 2020, so shortly before this entire epidemic hit, these protections under the Fair Employment and Housing Act were expanded to include what's called source of income. So what I'm going to show you here is these are some of the protections that already exist: race, color, ancestry, religion, sex, gender, sexual harassment, sexual orientation, gender identity, gender expression, national origin, marital status, and as you can see, source of income in the amended legislation. And this is protections that exist for you now. They went into effect on January 1st. And then there are some additional protections, for example, having children under the age of 18, having a disability, or any kind of medical condition, whether or not you're you're in the military or a veteran. Also, if there's genetic information that is released that a landlord somehow finds out about you that might make you predisposed to some sort of a disability. Also, you can't be discriminated against because your primary language is not English, because you weren't born in the United States, or based on your age or whether or not you're a citizen. I want to talk specifically about some of the Senate Bill 329, which adds protection to people based on discrimination based on source of income. So source of income means any kind of verifiable lawful income, obviously as long as that's not income under the table, so to speak, that's paid directly to you as a tenant or to a representative of a tenant. So if that tenant is somebody who is not representing their own financial interests, but has a power of attorney or a representative payee, this also applies to them. Also, income that's paid to a housing owner or landlord on behalf of the tenant, including federal, state, or local public assistance, or federal, state, or local housing subsidies. Now, what most people think of when they think of this is Section 8, either Section 8 housing that's municipal or transferable Section 8 certificates. Those are the kind of things that are protected under this act. Now, what's important to understand is that if your income is not from wages, but you have income that exists that you're getting every month, a landlord can't say to you now, well, I don't rent to people who receive Section 8, or I don't rent to people who get SSI. Landlords have to consider the whole picture, and they can't any longer refuse to rent to you because you get your income from public assistance, from Social Security, because you have Section 8, or any sort of housing voucher. This means that a housing provider can't engage in actions based on a tenant's or a prospective tenant's use of housing assistance that would be prohibited on the basis of any other protected class, such as race or religion. So, for example, a housing provider that you're already living in, if you then become eligible for a subsidy of some kind, they can't say to you, well, I'm not going to accept that subsidy, so you have to move. In addition, there is an exception. A housing provider can inquire about your prospective level and source of income. However, one additional protection that was added to this particular law was that a landlord cannot say to you arbitrarily, you have to have a specific amount, a specific multiple of the amount of the rent. So for example, landlords, what they used to do is say, well, I will accept Section 8, but you have to have income that equals 3 times the rent. They can continue to do that. However, they can only do that according to 3 times your portion of the rent. So if you're receiving a Section 8 subsidy that pays $900 out of $1,000 in rent, then they could say you have to have 3 times $33. So that would be $99 a month in income, at least, in order to be able to rent that apartment. They couldn't say to you, you have to have $3,000 a month in income. And that's very important because that gives an added level of protection to renters who may have limited income, who obviously are going to have limited income. And it was designed specifically because most housing subsidies are based on 30% of your income being the amount that you're going to pay for your portion of the rent. I want to talk about who needs to comply with this law. Any housing providers have to comply. This includes private landlords, property management companies, homeowners associations, corporations, and any others who rent residential property in the state of California. However, homeowners who live in their house condominium or any other single family unit and rent out only one room within that unit do not have to follow the law. So if you own a house and you're renting out a room, then this law does not apply to you. And if you are looking to rent a room from somebody who only rents out one room, then this law doesn't apply to them. So I wanted to give you an example of some of the types of housing subsidies that are included under the source of income law. Those include Section 8 housing choice vouchers, the HUD Veterans Assistance Subsidized Housing Program, the Homeless Prevention and Rapid Rehousing Programs, housing opportunities for people with AIDS, security deposit assistance programs. So if you are using any sort of assistance program to get your security deposit taken care of, but you're going to take care of the rent, the ongoing rent yourself, you still cannot be discriminated against for that by the landlord. Also, this includes locally funded subsidy programs created by cities, counties, and public agencies like community-based organizations to address growing homelessness. That's also really important because in some cases, the subsidy may not be coming from a federal program or even a government program. So, what is tenant-based rental assistance? I just wanted to talk a little bit about this. So tenant-based rental assistance, it's any sort of financial assistance that's paid directly to a landlord on behalf of a low-income tenant to help them afford market rent for privately owned housing units. As I mentioned before, usually these are based on 30% of your income is what's paid toward the rent. And that is what the landlord can consider when they're considering whether you have enough income to meet their qualifications to rent that apartment. Some other examples of tenant-based rental assistance include government entities, usually like the housing authority that pays the remainder of the rent to the landlord. Over 300,000 families in California receive this assistance, and local governments are also increasingly turning to this to provide housing assistance because we are, as you know, in an incredible housing crisis here in California, and we all expect that that housing crisis will increase as a result of the current pandemic and the economic effect of that. I actually already mentioned this before, that you are protected whether you are an applicant for an apartment or whether you're already living in that apartment. Again, there may be some economic downturn as a result of the current pandemic. We've seen it already. And we know that some people may have less income as a result and be applying for subsidies from various programs. And landlords cannot legally in the state of California say to you, well, I'm not going to rent to you because you applied for this housing program, or because now your income is coming from a housing program, or any other sort of non-wage income. So income that's not from working. They can't refuse to accept rent from a tenant who receives assistance after they've been admitted, and they can't refuse to rent or impose different requirements for someone simply because they receive housing assistance. This applies to a range of housing activities, including operation of housing, real estate transactions, financing and development, and land use decisions. So some examples of discrimination and prohibited practices. These are things that they are not allowed to do. They can't discriminate against or harass you. They can't make, print, or publish any notice, statement, or advertisement that indicates any preference, limitation, or discrimination. So they can't say no Section 8 in a housing advertisement in, like, on Craigslist, or they can't say no Social Security tenants or no public assistance. They also can't say to you, well, I was going to give you the apartment on the second floor that you were looking for, but because you're paying with a subsidy, or because your income is not from wages from work, I'm going to give you this different apartment that's a little bit smaller and doesn't have as nice of a view. That is also against the law. They also obviously can't harass, evict, or otherwise discriminate against any person in the sale of rental housing accommodations when the owner's dominant purpose is retaliation against a person who has opposed practices of discrimination. So if a landlord says, oh, well, I'm just going to sell the building so that somebody else will raise the rent, or somebody else will take it over, they can't do that if the purpose for doing that is because they don't want to rent to people who have Section 8, for example. They also can't discriminate against a person making available a real estate transaction, or otherwise make unavailable or deny a dwelling because of source of income. And they also cannot discriminate through public or private land use practices, decisions, and authorizations. So that means they can't enter into contracts or zoning laws or denials of permits for you to use a piece of property to rent to people who are on Section 8, for example. These slides I actually already went through, but one of the things that is important to remember is that landlords cannot refuse to complete paperwork required for you to begin paying your rent or using your assistance. And they also can't evict a tenant who's already been admitted because they receive a voucher and plan to use it to pay rent going forward. That's something that I know I've said that a few times, but it's important to remember because sometimes we have heard from people that that has happened. I'm just going to skip ahead a couple of slides. So are housing providers required to accept all applicants? So some housing requirers will say, oh, well, I won't, I don't like this law because it just makes me have to rent to anybody. And that's not true. Landlords are still able to consider some factors when they're deciding whether or not they're going to rent to you. For example, they can look at your rental history and require that you provide some references. They can look at your credit history, and they can look at your income eligibility. If you receive income that is less than your portion of the rent, obviously a landlord is allowed to say, well, I can't rent to you because, you don't have enough income to pay your portion of the rent. And that is both fair and legal, unless you're able to then show that you can get the income from another source to pay that rent. Housing providers must consider all legal and verifiable sources of income paid by the tenant or directly to the landlord on behalf of the tenant, including housing subsidies, but it's not limited to housing subsidies. If you have somebody who's going to sign and say, I'm going to pay the rent, or $100 of the rent for this person. Let's say you have a family member that says, oh, I'm going to help you out. I'll give you $200 a month towards your rent because they're fortunate enough to have the resources to do so. That also has to be considered by the landlord, as long as you have a verifiable form of rent. Now, if that person then runs into financial trouble and can no longer pay that rent, the landlord still has the right to then evict you if you are no longer able to pay that rent.
Brian,
Yes.
you have 2 minutes.
Okay. So I'm going to, I can actually wrap up with this last piece here. This is a really important piece that I just want to stress again. If the landlord requires a minimum amount of income, that's like, say, a multiple of your monthly rent, so your rent times whatever, and the tenant is using a housing subsidy to pay part of the rent, they can only consider your portion of the rent when they are calculating that income. And that's really important because that has been a barrier for people in the past who have subsidies, but who landlords would not accept as tenants because of minimum income requirements. I'm going to wrap up now and open things up for questions or comments. Why don't I turn it over to our moderators, Danny and Jacob, to let us know what kinds of questions and comments we might have.
Thank you, Brian and Elise, for being on our panel today. We really appreciate it. And thank you for all of our attendees. It looks like we have a question in our chat box regarding whether or not we will be covering tenant protections in Ventura County. Thank you for asking. And ILRC does serve Ventura, Santa Barbara, and San Luis Obispo County, although today was more information regarding Santa Barbara County and some of the statewide information. We also have our office in Ventura, which will research similar information for Ventura County. And if you'd like to put your email in the chat box, we can get you on the list to get more information in other areas. If anyone has any other questions that they would like answered live by the panelists, please put that in either the comment box or the chat box or the question and answer box. We will wait a moment to see if anyone has questions. Okay, well, it looks like our panelists did a great job of answering all the questions before they were asked. And I want to take a moment to thank everyone for participating. I will go ahead and leave the Zoom webinar open for about 5 more minutes, just so that we can collect all of the emails that are being put into the chat box so that we can make sure to keep everyone informed about what we find. So we will be here for a few more minutes if something comes up. Otherwise, thank you all so much for joining us for our very first Zoom webinar, and we look forward to seeing, in quotations, all of you very soon. Please also plan to join us for our Public Safety Power Shutoff webinar, which will be May 13th from 10:30 to 12, also on Zoom. Contact your local ILRC office or visit our social medias for more information on that one. Thank you so much.
Thank you, Danny.
Thank you. Thank you, Danny and Jacob, for helping us with this webinar. And thank you to all the participants.
I believe that Carrie earlier asked about links to the ordinances. Some of them have been a little bit difficult to find. So if you click through the articles that I put together, I linked to each ordinance, and you can find them that way as well. Santa Barbara is the only jurisdiction, and Goleta are the jurisdictions that have more descriptive information as of the time that my articles were published, which I believe was about the 23rd.
And it looks like we do have a question in the Q&A. Elise and Brian, are you able to see the Q&A, or shall I read it?
Oh, I can see this. Let's see. Would you like me to read? Danny, do you want to read it out loud for everyone, and I can?
Sure. The question says, is the health and safety exception applied to the safety of the landlord, for example, for an elderly person who is a verbally abusive tenant?
So the health and safety exception does apply for the safety of the landlord as well as the tenant or the neighbors. With a verbally abusive tenant, that might be something you want to look into a restraining order for as well. But courts are hearing emergency health and safety cases at this time.
Thank you, Elise. And I have something coming into the chat box. Let's see. Okay, Carrie is mentioning someone who is high risk and currently living at a friend's. Prior to the lockdown, she was asked to move, but now can't, especially due to the loss of work. She does not pay rent, and Carrie would like to know if she has any protection.
Well, I should start by saying I can't give any legal advice to anyone who's not a client. I can speak generally about this situation. It sounds like this person is a sublet. Based on what you're saying, Carrie, it sounds like this person may be a subletter. Some of the ordinances specifically protect subletters, but that's for rent deferment. If she lives in the home, it depends on what kind of agreement she has with the primary tenant. But again, the primary tenant wouldn't be able to utilize any kind of legal proceeding at this time unless it was some kind of emergency matter, a restraining order, a health and safety exception to remove this person. But I recommend that the person you're chatting about reach out to some specific resources so that they can help her, because it sounds like this situation is a little bit detailed and specific.
Another thing that I would suggest would be you could give ILRC a call, and we could get a little bit more information about the specifics of this situation, so that we can determine whether that is an advocacy issue or a legal issue, and we can refer you, either assist with advocacy or refer you to the appropriate resource.
And I'll put my email in as well, and my website, so you can contact me through those channels as well. I provide a sliding scale for individuals that are lower income and middle income.
Okay.
Any other questions?
This is Danny. I'm not seeing any other questions, so we will just wait for Elise to put her email in. There we go. Now you can contact her. I've also saved all of our chat information so that we have everyone's emails so that we can send more information later. This is Danny one last time, and I just want to say thank you all so much for participating, and we will look forward to working with all of you very soon. Have a great day.